The defendant, Mr. Eiserman, has come on into the courtroom. Again, it's Joseph Carl Eiserman III. He is currently in pretrial custody. Day 4, a sentencing, and Miss Simmons is now joining us, Mr. Stapleton. So you can step away from the table. It says pending. Looks like the alleged offense date was January 9th. Have there been any update to the status of that case?
Not that I'm aware of, Your Honor, no.
Yes, Ms. Gardner, what is it you'd like to say today?
This hearing opens like a routine sentencing, but within seconds it becomes clear this is anything but routine. We're about to hear from a survivor describing years-long trauma, a prosecutor pointing to a deeply troubling pattern, and a defense team trying to argue that the defendant has changed. But in sentencing, words only go so far. Judges look at conduct, history, remorse, and whether the facts actually match the apology. And trust me, that issue is going to become a major turning point in this courtroom. As you watch, ask yourself this: when someone says they're sorry but still seems to minimize what happened, should that apology carry any weight at all?
April 2nd, 2016 is a day I'll never forget. That is the day my life changed for the better and for worse. I say for the worse because that is the day I became a victim. I experienced hours of abuse, of being hit, slapped, choked, taken hostage in my own home and vehicle. A place that was once my safe place, my home, was no longer safe to me or my children. I never experienced this fear in my life before, the fear of wondering if this was going to be my last day alive, if it was going to be the last time I've ever seen my kids again or my family and friends. I was frozen, unable to defend myself against someone much stronger than me physically. I remember wishing for someone, anyone, to come save me, to knock on my door or even stop by and say hi, but nobody came. I had to save myself. After everything that had happened, I was afraid to be alone. I ended up living with my mom and her husband for roughly about 2 months. I didn't see my kids for about 2 weeks, roughly, so they didn't see the bruises on me. When I was finally ready to go back to my house, my mom and dad cleaned it up for me, so I didn't have to see any of the damages that was done. They replaced all my locks on my doors with new keys, so nobody had them but me. They patched everything they could to make it feel like a home again to me, but it wasn't. I was still scared to be alone. I ended up moving my brother in with me so I wouldn't be alone. I never went anywhere alone. The things that I enjoyed doing outside, I could no longer do out of fear. This put extra stress on my mom and dad because they had to do all my errands for me. I, as a victim of domestic violence, was put into counseling and therapy at Oasis for 3 months. I then switched my counselor to Life Skills and was in counseling for about 4 years. Therapy helped me overcome my fears of being alone, relive my trauma, love myself, and learn to see the red flags in people. I say for better because I no longer classify myself as a victim of domestic violence, but as a survivor. Although I will never be the same person I was before, and I still suffer from PTSD, I am now stronger than I once was. I am a successful mother of 3 children, a store manager. I own my own home, my new safe place. Since my case has been moving forward, I have found myself being more anxious and startled. I do have trauma that'll never go away, even with therapy. I just know how to handle my situations better. However, have a fear that Joe will want revenge when this is all over with. And for that, I am asking for protection for my kids and myself. I do not want what happened to me to happen to another person. And for this, I'm asking the court to give prison time, not only for the safety of me and my kids, but for the safety of the public in general.
I'll just say very unfortunate that it took this long to bring this case, to get Mr. Eiserman arraigned. Obviously, we were 9 years behind the ball. And I apologize to Ms. Gardner for that. Couldn't discuss that before. There's this behavior, which is absolutely abhorrent as it's described. Defense counsel has made arguments to me that the defendant has changed, but then we have this pending bond violation, which I think illustrates that he has not changed. Given that, I think 23 months prison was appropriate. It's what Ms. Gardner is asking for, a prison sentence. It's within the guidelines. I'd ask. Thank you.
Mr. Nago, sir?
Judge, a few things on behalf of my client. I think that the court can take probably unfortunate note of similar difficult cases where there's significant danger or attempted danger that a defendant may put a complaining witness in a case like this while on bond. That has not happened in this case. Mr. Eiserman, while he did move away from the area, reside in Illinois, and had some unfortunate and somewhat minor contact with the criminal justice system there, has been back in the area for approximately 5 years now. He's not contacted Ms. Gardner, has not threatened her or her children at all. And as the PSI writer indicated, his focus has been on parenting his 2 minor children. He was gainfully employed. Yes, of course, there's significant allegations pending in Mason County. I'm aware of those. I'm intimately aware of those as our firm is representing Mr. Eiserman and those as well. He's adamant of his innocence on those, but they did occur while on bond, so he doesn't shy away that they're there, and he just wanted me to emphasize to the court that he plans on fighting those till the end. I think that, Judge, in this case, certainly the description of the offense narrative taken from the police report and hearing Ms. Gardner's statements today are quite powerful, and I'm sure that they made an impression on the court. They frankly made an impression on me. My client did take responsibility. His version of the offense may be unsatisfactory. I'm sure it's unsatisfactory to Mr. Carnes as well as Ms. Gardner. But nonetheless, as Ms. Gardner just addressed the court, Judge, by him pleading guilty in this case, ensured a fast-track resolution, avoided additional potential trauma for her. The fact that he has been otherwise bond compliant, has had no contact with Ms. Gardner or her children, some additional insulation for Mr. Eiserman. Ultimately, he sits before you, Judge. His focus has been what has been consistent in my communications with him. He's worried sick for his children. I wasn't sure if I wanted to bring this up, Judge, because I don't have any supporting documentation, so I'm somewhat speaking as a lay person outside of my element here. I do fear that there's some mental health difficulties that Mr. Eiserman has that he has not self-actualized, have not been diagnosed. I know that from, again, having privy to some other materials, he has family members that are concerned about him potentially being an undiagnosed schizophrenic. His behavior and his ability to maintain focus and or his emotions, frankly, comes and goes even in his interactions with me. And he's someone that, and I was privy to another defense attorney making somewhat a similar point on behalf of one of his clients earlier this morning in the courts. My relationship with Joseph has always been positive. So when I noticed that type of change in a behavior of one of my clients, again, from a lay perspective, it causes me some concern, and hopefully throughout whatever period of incarceration the court determines appropriately, perhaps he'll be able to get some assistance on this. I certainly will encourage that he does so. That concludes my comments, Your Honor. We're not asking for any specific sentence. We're asking that you look at the totality of this, the report, the circumstances being as difficult as they are, and also Mr. Eiserman's conduct most of the time on bond, and fashion a sentence you deem appropriate. Thank you, Judge.
Is there anything you wish to say at this time, sir? You may remain seated because I know you got shackles or cuffs on. Whatever's the most comfortable for you.
See that my boss told me don't go with her. He knew her and her mother. he warned me that she'd been through multiple relationships as well as her mother Denise, multiple divorces. He told me not to go there, and I did, and I made it, and we did. I did make some mistakes. I loved her with all my heart, and I moved my children in, and I paid the rent. She quit her job. I took care of everything there, and her brother was already living there. She didn't have to move him in. He was living there because I said, yeah, you know, you know what, I apologize if she's hurt, and I shouldn't have caused her that type of pain, and I'm sorry for it. I'm sorry that I caused you problems, Jessica.
All right. In a criminal case, apologies are often wanted from the victim, and they're not always given. So I appreciate and acknowledge that Mr. Eisman gave one. Plus, obviously, there's the way the apology is made too that the court takes into consideration. You know, court, please think about the fact that he provided closure by entering a plea and avoiding a trial. And sometimes that's a very logical and reasonable argument to make. And as a judge, I never know what to say, because you're either damned if you do or damned if you don't with an appellate attorney or an appellate court. Either I say, yes, congratulations, let me knock off some time because you pled guilty, but then it looks like I'm punishing people who don't plead guilty. It's one of those things appellate judges never actually take, or courts take into consideration, or the appellate attorneys, because I don't know how, I don't even know how to respond. When I look at what the defendant's comments were a few moments ago, I was taken aback by them. In here, when I looked at his statement as to what happened, it says, quote, I pushed her away from me, end quote. Why did you do it? Quote, we were arguing about my ex-wife and I pushed her away from me, end quote. First of all, I don't know which ex-wife, because it sounds like, according to the PSI, he's still married to some woman someplace, and he got married to when he was 16. So I don't know if it was an ex-wife or the real wife, whatever. But the I pushed her away from me is not what happened. And the details in H's description of the offense are the ones that I take notice of. Well, nobody does this to me and walks away without finishing it, end quote. Pushed her, grabbed her by her throat, pushed her up against the wall, grabbed her by her head, slammed his forehead into hers, choked her multiple times, punched her in the mouth, side of her head. And that's only about 4 lines of 2-page agent's description of the offense. So I'm not going to read all those again, Jessica, because I don't want to make you relive them any further than you already have. But the comments today made by the defendant, as well as his explanation, are not at all what happened. Turn around and to blame the defendant and say, well, I was told I should never have gone there. That don't cut it. So.
Have you amended the report where it's
Stop.
omitted?
It's all right. It just is a, hold on. I'm not going to react overly negatively.
Yes, sir.
That's okay. So, Mr. Eiserman, I allow everybody to have their time to talk. I let them talk freely. I even tell them, like I told you, take your time. But now it's time where the judge gets to make a statement. It's my turn. Now, this did take some time to get to because the defendant had left the area. All right, let's take a look at the defendant's criminal history. He has 13 entries. We know that not all result in convictions. I acknowledge that. For instance, I know entry 1 of 13 was dismissed. Entry 2 of 13 was dismissed. So clearly, I don't take anything away from those. I will note that on 3 of 13, this one in 2004 occurred while on bond. Again, it was on bond for a case for which he was the charges were dismissed. But this one, we had an aggravated battery in Illinois. So already, starting from the very beginning, we're seeing crimes of violence. The defendant received a 3-year prison term in the Department of Corrections for Illinois. Then in 2007, after he had been discharged for about a year, he then picks up a domestic battery causing bodily harm, also in Illinois. He got 2 years of probation. That probation began on November 19th of 2007, and he got his first probation violation less than a month on December 7th for a new domestic violence case. Oh, I'm sorry, I misread that. So he actually violated probation, like I said, within a month on December 7th, and then again for a new domestic violence, which is entry 5 of 13, where the offense occurred on January 13th of 2009, and that was another domestic battery causing bodily harm. And so far, that means he's racked up at least 3 different violence. Well, he got 2 years of probation. That sentence began on March 23rd of 2009, and he made it less than 4 months because he violated probation on July 17th of 2009 by threatening a public official and driving while under the influence. So it's right back to a continued pattern of violence. In 2014, he picked up a drunk and disorderly. That was back up here. That's Wexford County. That was December 17th, 2014. He made it less than 2 years before he picked up another charge, and he picks up a domestic violence, which is the case that we're here for today. Meanwhile, that charge, he doesn't get arrested for about 9 years. Then he gets brought back here. In the meantime, while he had been gone, currently back to Illinois, he picked up an obstructing identification. I assume that means lying about his identity. 2 years later after that, he picked up a obstruct a police officer. Note here that one of these offenses was failing to obey a traffic signal. Not a big charge, but according to the rest of the history, he hadn't had a driver's license in nearly 13, 14 years. He's able to drive and do what he wants. And then I can take judicial notice and make a finding based upon preponderance of the evidence, the factors that have resulted in those new charges over in Ludington. Attached to that report was Ludington Police Department Incident Report number 26-2600. And that describes the allegations for the sexual assault charges pending against him in that county. Now, again, I don't make a finding of guilt, but I can take it into consideration in establishing a reasonable and proportionate sentence. Now, I'm not going to use it to exceed the guidelines, so therefore I use it for a very limited purpose, because I don't want to create another appellate issue. The amount of restitution being requested here, Mr.
Your Honor, I quickly did the math, the maximum for the hole in the wall, with the minimum for the phone, and arriving at $754.53.
That's another act of violence here. That seems to be a pattern for the defendant. Court sentences the defendant as follows: a $68 state minimum fee, $130 crime victims rate fund fee. Processing of this case has taken multiple months, including representation at a preliminary exam and multiple appearances here in court. So therefore, the court assesses a $300 court cost, a $300 attorney fee. The court assesses $754.57. 53 cents for restitution payable to Jessica Gardner. I keep it within the guidelines. This is a domestic violence third conviction. It also has a long history of alcohol and substance use. Its crimes crossed multiple states. The court sentenced the defendant to a prison term of 23 to 60 months, and the defendant provides the defendant 15 days of credit. I find that that is a reasonable proportionate sentence. I find that underneath the language of NCL 771.1, parenthetical 1, that the court is only to give probation where it feels there's not going to be reoffending. Again, the defendant has a very violent past. Therefore, I do not find that probation is sufficient and that this is a fair and reasonable proportionate sentence. Have I missed anything, Miss?
No, Your Honor. Thank you.
Mr. Mr. Carnes?
No, Your Honor.
All right. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document.
I have right to appeal,
I'm sorry?
so I can appeal this?
Yes, sir. It's by filing what's called an application for leave to appeal versus a claim of appeal by right.
Well, because she left out a bunch of shit on her stuff. She's like, well, the reason I lied about hitting him is because I didn't want to get in trouble. And the reason I lied about being at his ex-wife's house is because I didn't want. Of course you want to lie so that you don't get in trouble. We all want to lie so we don't get in trouble. We need to take that stuff into account.
Yeah.
She was a man-eater.
Maybe the defendant did the same thing. And I'm going to tell you, and I appreciate your compliments or comments because they get made a part of the record. And that reaffirms the court that the decision of the court in its sentence today is fair,
Okay.
reasonable, proportionate. Good luck.
This case ended with the judge sentencing the defendant to 23 to 60 months in prison while keeping the punishment within the sentencing guidelines and ordering $7,545.53 in restitution to Jessica Gardner, along with court-related fees. The court made it clear that probation was not appropriate here, pointing to the violent nature of the offense, the defendant's criminal history, repeated issues while on supervision, and the overall concern about reoffending. Just as important, the judge drew a sharp line between a true apology and a statement that minimizes responsibility. That distinction mattered here. A lot. And after sentencing, the defendant's own comments seemed to confirm the court's concern that he still was not fully accepting accountability. Cases like this show how victim impact statements, prior history, and the courtroom demeanor can all shape a final sentence in major ways. What do you think? Was this sentence fair, too harsh, or not harsh enough? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.